Good morning and happy Sunday to everyone. Welcome back to another episode of North Alabama Law Review presented by Johnston and Weston. I'm Shauna Hill, and of course we have Mr. Christopher Weston with us, and we have our new attorney, Mr. Russ Howison. Thank you for joining us again today.
My pleasure. Thank you.
He was so popular, we pulled him back again. Sorry, Russ, we weren't done with you, man. We had things to do.
There you go.
So Mr. Howison touched base on bankruptcy our last episode, and there is so much information to provide to our viewers for bankruptcy, so we kind of want to continue along bankruptcy on today's episode. So Russ, I'm going to go ahead and let you lead the way.
Absolutely. We are looking into a lot of the different ways that bankruptcy can help a lot of the clients that we already have. But we are always looking at the trends in the North Alabama area. We are very fortunate in this area not to be burdened with a high rate of bankruptcy cases, because even as the country was suffering with some maybe higher inflation or some higher unemployment, higher interest rates, North Alabama has kind of been insulated from that in some ways. So the last stats that I saw, which were from April of this year, the bankruptcy cases had only increased about 4% over last year in Chapter 7s and about 13% in Chapter 13s. But that's still way below the pre-COVID levels for the same period of the year. So we are still doing very well as far as the number of bankruptcies go. Now let's see how the furlough, as we're dealing with right now, might affect that. But I don't see that being a long-term issue. What we're going to be looking at, most of the cases that I get are cases that have to do with a catastrophic issue that someone has suffered recently, or an issue that they forgot about and has been creeping up on them for years. I consulted with someone that had a case from 6 years ago they'd forgotten about, had to bring it up and deal with it. So Chapter 7, Chapter 13 consumer bankruptcies will have a lot of tools to be able to help consumers. But one of the issues that I'm getting questioned about a lot right now are student loans. And student loans, I've been telling people as a practical matter, they're just not dischargeable. Well, it's not technically true because they are technically dischargeable. But you have to meet a very high burden in order to do that. The Department of Justice, in conjunction with the Department of Education, issued some guidance on that. It's on the North Alabama bankruptcy website, that sets out the scheme for being able to file for discharge of student loans. And it's a fairly high burden. It's called a Bruner test. But you have to actually file a lawsuit inside your bankruptcy against the Department of Education, showing all of your income, all of your expenses, your good faith effort to pay your student loans, and the fact that your circumstances are such that if you paid your student loans on time in the amounts that they're requesting, you wouldn't be able to live, and that your circumstances aren't really going to be likely to improve. So it's a pretty high burden. So practically speaking, when people ask that question, it's a difficult thing to go through, but I'll be glad to sit down and work through that process. We can look through your income, we can look through your expenses, and apply the Bruner test to see if it might be worth your while. Because a lot of people have education as fast as, especially in this area of our world, technology is moving so quickly. People are moving in and out of professions, moving in and out of jobs that may or may not use their degree or their education. So we have people that are working in fields that they don't have an education for, but it's because that's what they're trained to do. It's because they've got experience now. Or we may have people that have disabilities. We have people who've been through car wrecks that aren't able to pay student loans. There are a lot of issues that can affect that. So we need to sit down and take a look at their finances in addition to the regular bankruptcy financing to see if we can actually get them through the Bruner test to deal with student loans. If you meet that burden, you can actually have some or all. It can be a partial discharge or a full discharge of student loans. But in my experience, it's been very rare. So bringing people in to be able to look at those. But I also get questions, and I'm getting increasing number of questions from creditors as well, and how their rights are affected in bankruptcy. So I hope to be able to represent a lot of small businesses that may have questions about dealing with clients that they love to deal with but are now facing bankruptcy issues, and just ordinary course of business.
You know, we deal with that a lot. I deal with that. I know we both deal with this a lot, is where, you know, a business will be suing someone who owes them money, or they'll be negotiating, or, you know, what have you. And, I tell clients all the time, it's, getting a judgment is one thing. Collecting on it is something different, especially in the contract world. I cannot state how many times, we'll have won a case, gone all the way to the wall on it, and I mean, absolutely just best day, sun is shining, just absolutely won an amazing case, an amazing verdict. And then when you go to collect, it's a whole different process. I mean, it's almost like a whole new litigation a lot of times. And that's also why, I tell people, having a lawyer review your contract, even when it's a simple contract, you're dealing with, okay, who are you dealing with? Doing a background check on them, which, you don't always want to do for every agreement. It'd get a bit obnoxious at that point. But, making certain that there are remedies in your contract, or remedies, even if you do have to proceed to litigation, to be able to collect. Because now, judgments, they're good for 10 years. You can get them recertified, obviously, to where they're essentially good for 20 years. So if someone gets better, if things happen, and their life improves, that you can collect on them. But not when you're dealing with bankruptcy. I mean, I've seen entire litigations consistently get stayed because we sue, we're pressing forward, everything's going well. A lot of times they'll try to deny the debt at first. We prove it, we get through, and then they file bankruptcy. And then the entire case is stayed until the bankruptcy deals with it, or the bankruptcy court deals with it and decides if it's going to be discharged, not discharged. It is an entire process in and of itself that can stop a case dead in its tracks. And so how do you kind of deal with some of that, just very superficially? Now, I know we'll get into more detail with it at another date, but this is something I deal with a lot on the business side, is a case being stopped with a stay. Can you lift those stays? I mean, I know we can, but, I would like you to kind of describe that process for us, if you don't mind.
Absolutely. The determination about whether or not a lift can be granted from the automatic stay, what he's talking about, when you file a bankruptcy, there's a federal order that goes out that stays any collection matters. Collection matters. When you're dealing with litigation, there are a lot of different types of litigation. Some of them are stayed, some of them are not. Some of them can be resumed, especially when you're dealing with family law issues where child support and custody are major issues that need to be dealt with. You don't want to have to stop and wait for a bankruptcy to deal with child support. So there are certain issues that will be able to be continued. One of the major issues in making that determination is, do we have a secured debt? Is the debt that is owed, is it evidenced by a judgment? Has that judgment become a lien? Has it been perfected on a piece of property that we need to pursue action to be able to collect on it? Is it something that the bankruptcy court's going to have to do through the trustee? So we'll have to take a look at the totality of circumstances and the type of debt that you have to find out whether or not it's something that the court would look at as being worthy of having the bankruptcy stay lifted. Do we have something we can pursue? Typical unsecured debts, credit card debts, they're not going to get the stay lifted. Doctors that have large bills, people have been through car wrecks and went to the hospital and have a large hospital bill. The hospital is not going to have the stay lifted. But there are other issues of more severe nature, more of an important nature that the court will recognize and grant a lift stay in those cases.
So a follow-up question for that. You mentioned about if it gets stayed and, will it put a hold on it while you're going through it? Mm-hmm. But let's just say we have a case, we win, we get a judgment issued, mm-hmm. and after the judgment has been issued, that person goes and files bankruptcy. Right. What happens then?
Well, the judgment is not a lien against any property that they own until it's been recorded in the probate records. If the judgment has been taken and recorded in probate, it becomes a lien that is now perfected against property that they own in the county. So at that point, you have a secured lien on their property. So do they own anything? Is there something here that we can pursue? If you have a secured lien and they have the asset that's protected in bankruptcy, you have the ability to pursue it through the bankruptcy. You have to go through the procedures in the bankruptcy to do it. If you're dealing with a Chapter 13 or a Chapter 7, that means talking to the trustee, because title to all of their assets is held by the trustee until a determination is made. If it has not been perfected, in other words, if it hasn't been recorded in probate, you still have an unsecured lien, and you don't have the ability to have the stay lifted unless it's for certain things like child support or damages that came from a drunk driving accident, something along those lines. Then you have very serious issues of non-dischargeability, fraud, those types of things. But generally speaking, without dealing with those specific issues, if you just have a general judgment, you're stayed, you're stuck, it's an unsecured debt.
And it's a quick check to see if someone has property in a county. So again, talking about checking up on contracts, see how rooted they are around you. You know, I know that seems kind of antiquated to people now because we're so used to, you know, computer and technology agreements where it's like, we're buying a computer, we're buying this, we're buying that. But when you're dealing with, you know, again, home renovation, any major contract, doing a little bit of due diligence on somebody is really not a bad way to go because it doesn't take a lot of time and it can protect you pretty significantly. I mean, wouldn't you say, Russ? I mean, I deal with that.
Very much. If you have not protected yourself according to the terms of your own contract, or you are not able to protect your business, your assets, your money, your time, because something got left out or was added in that you didn't need or didn't want into your contract, that could have been an ounce of prevention that's worth a pound of cure. So we have a lot of things that we can do very quickly, title searches being one of them, filing liens if you have a contract that ties to specific property, UCCs, mechanics and materialmen's liens for guys that are working in the construction industry. All of these are available to you in order to give you a little bit more of an edge if you wind up in a bankruptcy situation, because then at least you have the security of that lien that can be argued in a bankruptcy scenario.
Interesting.
Gotcha.
Okay.
Thank you. I'm pretty sure we'll get a lot more questions following up with that.
For sure.
Be prepared.
Undoubtedly, you'll be back.
Well, we're going to jump into a couple questions if you guys don't mind.
Sure.
Chris, I'm going to go ahead and start with you for this first one since it's right in your area of expertise. We do have a question that says, I have a business with a family member, but they did not create an operating agreement. Is it too late to do one? And how important is it for a business to have an operating agreement or bylaws in place?
Okay. So I'm going to jump in on this one, then Russ, when I'm done, jump in too, you know, with anything you think I missed. So no, it is not too late to do an operating agreement. It's actually never too late to do an operating agreement, which is one of the great things about operating agreements. Same thing with bylaws. You can always do them. However, pursuant to the statute, to bring in an operating agreement, if you're already running that business together, everyone's going to have to agree. And that's where you're running into a little bit of a problem is that if you, and again, maybe I'm reading into this question, but if someone's asking this question, usually that means there's not a conflict yet, but tensions are a building. And if that happens, then, you know, understand that your new operating agreement is going to have to be agreed to by unanimous consent in every instance I can think of. Now, amending them can be a little different, but generally speaking, again, especially if you're running an LLC or a corporation or anything off of a statute, which you can't really do easily with a corporation because it has so much more formality to it. But since they've asked specifically about operating agreement, I'm going to assume LLC, because when you're dealing with a corporation, you're dealing with articles of incorporation, you're dealing with bylaws. You're not usually dealing with operating agreements. It's primarily LLCs. And so, yes, you can do one. Yes, you should do one, because they are very important. Because I've referenced in another episode that, like, if you're running an LLC without an operating agreement, what you are doing is whatever, you know, if you have a 90% owner and a 10% owner, they have equal voting power. There are, you know, most things can be done by a majority of the vote of the members as far as just general actions in the day-to-day business of the LLC. Problem is, nobody has a majority of the voting power anymore, but they can each represent themselves as an agent of the company to third parties. And so what you end up happening is, again, you may have a 10% owner and a 90% owner. As far as outside world goes, you have equal authority to bind the company in just about every instance, which is a huge problem. And we call that agent principal law. We call that apparent authority. So without an operating agreement, as far as third parties are concerned, everybody has an equal right to bind the company and make deals in the name of the company. Same thing with other day-to-day matters, accounting, tax matters, writing checks, getting account information, unfortunately cleaning out a bank account. And so without an operating agreement and without having that published somewhere, such as in the probate office when you initially form, it's not so much a problem with your business not being able to run or that your business is running illegally. It's more the kind of problems you can run into in trying to resolve issues internally, and also representations that you have now impliedly made to the public at large. And so if things go sideways, they can go sideways in a very big way, and then you are coming to our office or some office. Now you're dealing with a litigation matter. You can be dealing with, debts, creditors, purchasing, all of it.
So if something does go sideways, and not necessarily for the business, but more so Russ in bankruptcy, let's just say if you have a partnership and one partner ends up in bankruptcy, can that affect the whole business? Is there anything that you can put in your bylaws or operating agreement to alleviate from that? What can you...
Absolutely. The lack of having an operating agreement, you're left with the Alabama code and on how the company's got to be operated. So now you're looking at the standard kind of generic template for how a company's going to be operated under the Alabama code. But a lot of times you have contracts that you're dealing with that has bankruptcy as one of the defaults. If you file a bankruptcy or one of your members files for bankruptcy, now your company may be in default, your partnership may be in default. Ownership of an LLC, ownership of a company interest or partnership interest is something that has to be listed as an asset in a bankruptcy. So you're going to have to deal with a valuation at some point, and if you don't have an operating agreement as to how that company is going to be run, you are in a bit of a limbo. You can still operate according to the generic terms under the Alabama code, but you've got to have that business continue to operate, or you may wind up having triggered a dissolution. And what I mean here is this is an event now that the company, if we don't do something, the law is going to treat it as being dissolved and not there anymore. So how do we continue the operation of the business with one of the partners in bankruptcy? The operating agreement would be able to handle those terms. It would be able to set those triggers and say, look, if somebody that's a partner in the company files a bankruptcy, here's what we're going to do. The other partners may be able to buy them out at a discounted rate.
Right of first refusal.
Right of first refusal will have a valuation that's set at $5 a share or $5 for your entire interest, whatever the case may be, just to be able to get the control out of their hands and into the hands of the people so they can continue operating the business. But there again, if you're transferring interest in a partnership or an LLC, you're transferring an asset that might be an issue for you in your bankruptcy.
Mm-hmm. Don't get involved in fraudulent transfer. Don't do it.
Generally,
so many people try it too, and it just never works out because, if you track it down and you can prove that fraud, that can even throw out your bankruptcy, right? I mean, that's my understanding of it.
The bankruptcy trustee will take a look at transfers made within 6 months to 2 years prior to the bankruptcy. And if there was a preferential treatment of a creditor, or if somebody was an insider that got a preferential treatment to be able to purchase an asset or hold an asset on your behalf while you're in bankruptcy, the trustee has the right to nullify that agreement and pull that asset back.
Yep. So don't do it.
Well, we got one more business question. It's kind of on the other end of the spectrum. If you're not having problems internally, but externally. So if you have a local vendor or a client who has breached their contract, what's the appropriate way to handle that?
Okay, I'm going to start this one off, Russ. Let's go. I love this. So, if they breach their contract, and that's why I love questions like these, because I handle them one way, and it's effective. Russ is going to have a slightly different way, and Bennett, who's been on this show, has another way. And that's why having numerous lawyers look at something is, just extremely beneficial, because, especially within one firm, because you can see all the different angles, right? I mean, everybody has their own way to shoot a basketball, throw a punch, file a lawsuit, right? Or deal with, a bad debtor. But basically what you need to do to begin with is review your contract. See if there are any specific notice provisions of default that are necessary, because especially in this world of AI, don't even get me started on AI with this.
There's your trending question for next time.
No, we've done one, and my opinion of AI is...
Here's John Connor.
I am the resistance, okay? I'll tell you right now, 100%.
There you go.
But a lot of times in your contract, if someone is defaulted, not paid, there are specific things that you have to do in that contract to basically perfect that default. Send a notice to a specific place. Send a letter to a specific place. Tell them in person. Try to mediate. Go through arbitration. And what you don't want to do is just sit on that default, and then eventually it gets to a breaking point, you sue, and then there's some problem, something you didn't follow that you were supposed to follow in the default world, okay? And so first thing to do is look at whatever agreement there is. And if there isn't one, then okay. Still, next thing to do is reach out to them in writing and say, you have breached, you're in default, you've not done something you were supposed to do. Usually that's, you owe me money, okay? You owe me X amount of dollars, you've not paid since then, this is in violation of our agreement, okay? And once you've put them on notice, you can try to negotiate with them. Usually at that point, though, if you're at the written notice point, I recommend getting an attorney. And this is why. If they were going to pay or could pay, generally speaking, and it wasn't going to be an issue, well, it wouldn't have been an issue to begin with. And so as they're explaining things, as you're trying to discuss it, I cannot tell you the literal number of times we have seen somebody come in and, talk about the debt, we go forward, we start making demands. And that conversation's been recorded, and they made representations. They did something to try to appease. They tried to avoid court. I understand wanting to avoid court. I understand wanting to avoid, lawyers and litigation. But I have seen things become so much more complex and so much more of an issue because people tried to avoid the law or tried to avoid, legal advice than I ever have seen someone just take appropriate steps, deal with lawyers as you need to, and move forward. And so, again, review your contract, give them notice, see a lawyer. And, just be very careful about what you say to anybody when you can't see them face to face, and that even when you can, because you don't know if they're trying to back you into a corner. Russ, what about you, man?
That's great advice, because under Alabama law, you have to give them notice of their default and an opportunity to cure. A lot of people will bring us cases where there's been a breach of contract, and it's already gotten to the point where I don't want to talk to them. I don't want to give them an opportunity to come back out here and do something else and mess it up even worse. Law says you have to give them an opportunity to fix the breach before you turn around and hit them with a lawsuit.
Yep.
So there are ways that we can deal with this, but I have found straightforward ways instead of trying to do twists and turns and backhanded attempts at resolution. If you can be direct with a person and open a discussion, you're going to be a lot further on, because justice is found outside of the courtroom. Typically, it's resolution that's found in the courtroom. So,
yeah.
Seek an
All
attorney.
right, guys, thank you for that one. We have a
lawyer
couple
time.
minutes, so let's squeeze in just one last question real quick.
Okay.
So this one is on a little bit different area than bankruptcy and contracts.
Oh.
So collect, guys. This one is actually about home ownership, insurance claims. So what steps should you take if you are a homeowner or auto insurance claim has been denied, or if your insurance company tries to undervalue and underpay your claim?
I've answered a lot of questions on this. So, Russ, you want to go first, and I'll jump in?
Oh, goodness. These are typically done in such a way that you don't have enough value here to file a lawsuit to pursue the claim any further. We're going to shortchange you just enough that it's going to tick you off, but you're not going to have enough of a problem to go hire an attorney.
Yep.
So that's typically what you're dealing with, is somebody who's doing it just to be a nuisance because they know you won't pursue them. There are ways that we can help you go through the process of pursuing your insurance company for justice, because what you're looking for is full payment, complete payment, or if it has been denied outright and there's not a good reason attached to it, you actually have a claim of bad faith that could be leveled at an insurance company for not granting that claim, not dealing with your claim in a good faith manner. So you have some options that are available to you, everything from us guiding you through a small claims case against them to a bad faith case against them for breach of their contract, their own insurance contract with you, because they have an obligation to deal in good faith and fairness with you.
Yeah.
So that's what we would stand on with them.
Absolutely. My recommendations is, again, make sure you have a copy of your contract, photograph everything, get an estimate from an independent estimator if you need one. Okay, you're not bound to use theirs. Yes, their contract is going to give them sometimes the right to select who they want to, but nothing stops you from getting an estimate to get proof that they've really lowballed your claim. Okay, nothing stops that. Yeah. And so being able to, again, contract, photographs, someone else who is an expert who can come out, review what's going on, and be able to give you, an alternate opinion, or they may even say, no, your original adjuster's correct. And getting those things, and then getting legal advice quickly, okay? Because again, if you're at the point where you think they are doing so bad by your claim that you need somebody else to come out there and give you an objective other opinion, it's to the point where you likely need a lawyer. Now, you can reach out to your adjuster and say, hey, I got someone else to come out and evaluate this. Here's what it should cost. This is local. My contract says that, you guys are supposed to cover this. And here's a bunch of photographs of what, taken by you and by whoever you got to come out there. Says, here's a bunch of photographs on this that says, you're not doing right. And they might straighten up. I've seen it happen, especially with engineer clients who have everything just documented down, to an absolute T. I've seen it happen.
Gotta love engineering.
But, oh man, yeah, magnificent. Especially here in Huntsville.
Oh, yes.
But kind of what you were saying, Russ, is that it doesn't necessarily mean that you have to come to a lawyer and just have us completely handle the case. Right. We do consultations. Lots of places do. They'll do them for a fee a lot of times for this exact type of circumstance where it's right. Like, okay, as you have a small claims, it's like a one-page document. You're going to need X, Y, and Z. You're talking about a $2,500 difference. Here you go. This is what you need to do. And so there's a lot that can be done that doesn't mean that we have to take over your claim or your life, or right. Any lawyer has to.
I think that's definitely valuable information as the weather transitions from warm to cold and we see tornado weather and storms coming through. Those insurance claims are definitely going to take effect. So definitely good information to keep in mind.
Absolutely.
Well, guys, that is all of our time for today. Thank you guys so much for tuning into North Alabama Law Review. Again, please submit those questions at legalhelp@jmmtlawfirm.com. We'll be happy to answer them on air. And we hope you guys have a great day. We'll see you next Sunday.
Have a good one.
Thank you.